Okay, on to Lively's opposition to defendant's motion limine number 10, which is to preclude evidence and argument concerning retaliation in anticipation of future protected activity. You're saying, she's basically saying, look, I want to be able to bring in evidence and arguments because I believe that, there was retaliation because Wayfarer, was anticipating future protected activity. And like, you can't say they've retaliated against something that hasn't even happened. That's just, I think that's such a stupid argument. It just makes my blood boil. Okay, let's go for this. Defendants attempt to preclude Lively from introducing evidence and argument concerning defendants' anticipatory retaliation measures is contrary to both governing law and the record before the court. Their motion incorrectly asserts that retaliation can only be based on past protected activity. That is not the law under the California Fair Employment and Housing Act, FEHA, I should have just said FEHA, which governs Lively's retaliation claims. California courts have expressly recognized that FEHA protects employees against preemptive retaliation. Indeed, adopting the limitation defendants urge here would create a perverse incentive for employers to retaliate against employees before they have had an opportunity to complain or oppose unlawful conduct or file claims regarding FEHA violations. I mean, I suppose there's a difference between, like if you're put on notice, like you've got 28 days, or I'm going to file a lawsuit against you, right? Then yeah, maybe you can say there's preemptive retaliation because you are anticipating a lawsuit that you have been put notice on is going to be forthcoming. But she's saying, well, in August, Wayfarer were anticipating that she was going to file a CRD or sue them when there was nothing of the kind. There was no evidence whatsoever that was going to happen. She did not put them on any notice, and she waited half a year herself to even file anything. And the reason I don't think she was ever going to file anything, certainly not in August, is because she didn't have any evidence. She didn't have evidence at the start of August when she's saying, well, there's, they were preempting I was going to file a lawsuit. Didn't have the evidence from Stephanie Jones then. She didn't get it until the end of August. And then in reality, and then she, didn't get it again until the start of October when, Van Zandt, presented Stephanie Jones with, it served a subpoena on Stephanie Jones and Jones Works. So she didn't have all the evidence properly until the end of October, by which point she had all the evidence, but she was, too focused with the New York Times on writing a hit piece. So there's I just can't see that no one was anticipating a lawsuit at the start of August. So I can't see it. As stated in Steele, the legislative purpose underlying FEHA's prohibition against retaliation is to prevent employers from deterring employees from asserting good faith discrimination complaints. Employer retaliation against employees who are believed to be prospective complainants or witnesses for complaints undermines this legislative purpose just as effectively as retaliation after the filing of a complaint. To limit FEHA in such a way would be to condone an absurd result. I mean, and someone will say, well, Steve Sarowitz kind of indicated to Claire Ayub in that recording that, they were anticipating something. No, what he said was if because effectively the marketing had ended, the film had premiered, the relationship had ended. I think at that point they were anticipating it potentially that the sequel was going to start to, to go into production next, and they would have to work with her again. Everyone keeps forgetting this and thinks, well, that was the end of their working relationship. And technically it was. But there was also a sequel that was, it was due to be started too, which Wayfarer would have been the production company for that, along with Sony. And, I think Baldoni would have had far less involvement in terms of the lead actor. And, I think he'd already said that he was happy to hand the reins over in terms of the, director to Blake Lively. So, I think when Sarah is at the end of August is saying to Claire, "Are you?" Well, if she crosses the line or if she tries to do anything, to ruin Wayfarer, we will be ready. We will, be ready to defend ourselves. That's because I think they anticipated that they have to continue working with this woman. I don't think it's because they were like, right, okay, well, she could go to court any time now, and because like, how long would that go on for? How long would they have to anticipate she might might bring a lawsuit against them? So I think it's being misconstrued and misplaced, probably deliberately by Lively. Accordingly, evidence that defendants acted to punish or deter Lively from further opposing lawful conduct or anticipating that she might file an administrative complaint or lawsuit, both of which are protected by the participation clause under the Government Code section 12940H, is squarely relevant and admissible. I mean, surely if they retaliated and tried to destroy Lively's reputation, etc., that wouldn't deter Lively from taking action. Wouldn't that just provoke her to do it? Exhibit A, this lawsuit. But that wouldn't, how would that deter Lively? I just think that's because the only way they can say that, a lawsuit would, that filing a lawsuit would be, no, the only way that I can see in this scenario that Wayfarer could have potentially taken action that would have deterred Lively from filing the lawsuit is if they had filed their lawsuit against her first. But they did not do that. They filed a lawsuit against the New York Times for defamation, which they're perfectly entitled to do. New York Times have not got that kind of, they've not engaged in protected activity. They're not protected by FEHA. They can't claim retaliation. And they filed the lawsuit against the New York Times. I believe, and I stand by this, Lively filed the lawsuit in New York, which she never planned to do, for no other reason than to be in control of discovery. Because when you are a non-party, as Lively herself has done to people like me, to Cassidy, to Ashley, to Lauren, when you try to say, hey, hold on a minute, I don't want you to have all of this information about me, I don't want you to have my private stuff because it's not relevant and I'm not a party and you're dragging my shit into something I don't want to be part of. Blake Lively has been more than happy to point out that we have no standing. And she would have had less standing as a non-party to have control over which of her text messages were shared, what discovery Wayfarer could have potentially done on the New York Times. And I think we would have found out more of how much of a shit show this was and how long it had been planned. And I think it would have solidified even that potentially that Van Zandt, that subpoena was used specifically to give it like, a veil of litigation privilege. Because there's no way that the New York Times did not question who the hell is Van Zandt when, they verified that there was a subpoena for all the documents that were being used. But they did not file that lawsuit first against Lively. They filed it against the New York Times. I stand by, I think Lively only filed the New York lawsuit to take back the control. And that's, it all got consolidated and everyone got brought in. And Wayfarer abandoned the California claim against New York Times and brought them into their own New York thing. I mean, Wayfarer filed their New York lawsuit not in response, but they filed it subsequent to Lively's New York own filing in New York. So how is that a deterrent? is my question here. Tellingly, defendants rely largely on federal authority interpreting Title VII and New York State and local retaliation statutes, none of which govern Lively's FEHA claim. While California courts draw guidance from Title VII case law, FEHA departs in key respects, including that it protects employees against preemptive retaliation. Even if the court did look to defendants' Title VII cases, they are inapposite. The few California cases that defendants cite are easily distinguished, the key difference here being that there is no dispute that Wayfarer and Ends With Us movie were aware of not only Lively's concerns and earlier protected activity, but that they also expected that she would engage in further protected conduct, including by making her grievances public through legal filings. Is that the evidence there for that? Heath expressed to Hoover his concern that Lively would bring sexual harassment claims. Did Heath confirm that, or is that the word of Hoover? In Jadian, for example, the court refused to find retaliation based on an employee's statements to a co-worker that he felt discriminated against, but only because those statements were not reported to management and therefore did not put the employer on notice of the employee's concerns, an issue not present here. I mean, no, it is present. I'm sorry. I do think it is. That's exactly what I said. She said she was willing to forego a HR complaint if all of these demands were met. They were all met. Everything was fine. Why would they then retaliate? Why would they retaliate? I'm not seeing the motive here at all. They may have had concerns that she was going to, because she was dripping things into the press, and they were, as Lyman said, they were able to rehabilitate and, defend Baldoni's reputation whilst also showing that she's not a credible person. They're entitled to do that. But that is not retaliation in anticipation of a lawsuit. I hope I'm making some sense here. Because there's no need to do that in terms of past problems. But also, nothing happened going forward then for months. She did not file the lawsuit for, a further 4 months. And she did not put anyone on notice until the day of. Like, literally, with the CRD, she also sent the cease and desist. And then proceeded not to give them, the notice, I think it's 30 days, to kind of remedy the situation. She just filed, and that was that. And put it out in the New York Times, by which point they were also entitled to defend themselves, because it's now on a global stage. Seems Lively and Reynolds like global stages. But no, I don't agree that there are no issues here. We're about to find out why she thinks there isn't. An issue not present here. Defendants' reliance on McKenna fares no better. There, the court found only that the plaintiff failed to plead a causal connection between her alleged protected activities and termination, without addressing the termination was anticipatory. No, I'm not buying that at all. Because they clearly showed that they used that case specifically to say, hold on a minute. Everything you made all these demands, everything was fine. Your own words, everything was fine. We got through phase 2. Then suddenly you had to take a stand out of nowhere months after the event and not promote the film with me, which everyone knows fine well was just to generate headlines, which it did. And then that would allow Lively then to be saying, people were speculating that there was a feud. So things then were being dropped in, oh, well, he fat shamed me, he lingered with his kiss, blah, blah, blah. And then obviously that's getting, people are talking. People are talking about that. So yeah, they're anticipating maybe, she's going to go public, right? And how are we going to deal with that. Well, they're not going to sit there and just let you do it. But I still think, like, I don't know, I'm getting annoyed now, but I feel like, everything was fine and everything was carried out, with Lively's strict kind of demands, and, all her wants and whims were, you know, given into. So why all of a sudden, and this bothers me a lot, how was she able to get through the second half of filming, including intimate scenes with Justin Baldoni, but in January and February of 2024, but by May, June, July, she couldn't bear to be standing next to him in the marketing or sitting next to him whilst having an interview? How does that does not even make sense. So no, I don't. I think, they may have been like, I'm sure Wayfarer are just as puzzled as I am at the moment. Like, okay, well, you've suddenly got a problem again. Where's this come from? Everything's been fine. And I think it was she wanted the franchise, but I think she's tanked her chances of getting the franchise now. And she may even have taken advice of Alex Sachs about this as well, for her role in what happened on the set of Florida Project. Okay. Further, defendant's final California case, Adams, supports rather than undermines admissibility of evidence and argument regarding retaliatory acts taken in anticipation of further protected activity. There, the dispositive inquiry was whether the decision-maker knew that the plaintiff had previously reported concerns about a public policy violation when he decided to terminate her. He did not know, and therefore could not have terminated her in retaliation for doing so. This is consistent with California law that protected acts must be viewed in the totality of the circumstances, and that an employee need only sufficiently convey opposition to unlawful conduct to be protected. The court has already recognized this principle here, finding that a jury could find that the Wayfarer parties were motivated not just by fear of what would be disclosed, but by the protected actions Lively had taken in the past. The record is clear that by summer 2024, when defendants were scenario planning ways to bury Lively, defendants were on notice of her protected activity, understood Lively thought that they had behaved in a discriminatory manner, and also expected Lively would make her grievances public and/or file legal claims. I'm not convinced. I'm not convinced by this. As a direct result of fears that Lively would do so, defendants decided to go to war and consulted with their current counsel, Brian Friedman, based on a recommendation that he's a killer and would bury Blake. Someone told Lively that that's not quite literally what he is. On this record, defendants cannot reasonably dispute that the alleged character attacks were undertaken because they feared Lively would publicize or legally assert allegations that they had created a hostile environment in connection with the film. To preclude Lively from introducing evidence and argument related to defendants' fear that Lively would speak out and or assert claims against them, the proactive steps that defendants took to deter that activity, and that such steps constitute unlawful retaliation, would create precisely the absurd and perverse result California cautions against. Indeed, it would allow defendants to present an unchallenged story about how they allegedly took only reasonably defensive measures without giving the jury essential and necessary context from which to infer that defendants' retaliatory campaign was undertaken both on Lively's prior protected acts, including the Protections Agreement and January 4th meeting, among others, and also to preempt and deter Lively from speaking out or filing claims against them. Okay, but on that basis then, I think if we're going to go in with that, I think she also has to, allow in things like Ranzan. I do. It would also signal to employers that if they act quickly enough, they can retaliate against an employee that they know has concerns, including by publicly attacking their character, so long as they strike first. FEHA does not permit that result. Accordingly, the motion should be denied. Okay. I did not like that at all. But I've talked about it enough, so I won't talk anymore. Okay, so the next video is going to be defendants' opposition to defendants. Motion in limine number 11, which is to preclude Lively's prior descriptions of her experience. This should be interesting.